Hi, my name's Don. I'm talking today about fighting California traffic tickets. And this is new to me. I apologize if you saw my earlier stream. I didn't say anything for half a minute or so. But anyway, so I'm not sure how much of this is even going out because I can't see my picture on my computer. So I'm guessing it's working, but I don't know. So I'm just going to pretend like it's working and continue. So basically, in California, the court system can be very beneficial to you if you're fighting a traffic ticket. It's less formal than the criminal system, probably in many ways, and less formal than the civil system, I guess, in most areas. But the California law provides that all the courtroom rules that apply to felonies and misdemeanors also apply to traffic tickets, with just a few exceptions. And one of those is a jury trial, for example. You can't get a jury trial for your red light camera ticket. You might want a jury trial for that, but you can't get it like you can for a misdemeanor or a felony. And that's why, by the way, your fine is $490. If they made it $501, then you'd be, according to Supreme Court case precedent, you would be eligible for a jury trial, even though it's an infraction in this case. So here's my advice for your traffic ticket. And keep in mind, I'm not a lawyer. I've never been a lawyer. So I don't counsel people. I don't charge money for counsel on traffic tickets, but I do have a pretty good record on traffic tickets. In particular, I've beaten 4 straight moving violations in Ventura County. 3 of those were red light cameras, and 1 was an illegal lane change. All right, so enough of that. First of all, if you're fighting a traffic citation, I would seriously recommend David Brown's book called Fight Your Ticket in California. You can get that on ebook if you want to get it from Google Books or Amazon or whatever, or at your local bookstore. It's money well spent if you get it. And if you read it and if you commit yourself to understanding it. So that's advice point number 1. Just get that book. It'll tell you about different tickets you could have gotten. It'll tell you about different strategies for fighting citations. And I would highly recommend it. Okay, generally speaking, in traffic citations, when you're pulled over, don't make yourself memorable at all. You don't want to tell the officer any jokes. You don't want to threaten to to see the officer in court. You don't want to tell the officer he's stupid or she's stupid and didn't really see what they say they saw. Just answer their questions, yes or no, if you feel like it. If you don't, you have a Fifth Amendment right not to do that. And don't say, if they say, well, you're in a hurry to get somewhere, either keep your mouth shut or say, no, not really. But you don't want to make them think that you're even considering fighting this citation. But they're going to try to get you to admit that you did it. They're going to say, well, you do know that it's illegal to run stop signs, right? And you were moving, correct, when you went into the intersection. You never did stop, did you? If you admit something like that, they can use that in court when they go to court. If they see you in court, that's the first thing they're probably going to say, or one of the most important things they're going to say is, Your Honor, this defendant told me that they were in a hurry to get to school to pick up their kid, and that they knew they had not come to a complete stop, but they thought it was safe to go anyway. That's one of the things we can guarantee that the officer will say. You might instead want to say, Officer, is it possible for me to pay this by mail or go to traffic school on this, or whatever? Get the idea that, and yes, you can pay by mail, and they will tell you, yes, you can pay by mail, and or go to traffic school, whatever you want to do. That'll all be outlined on the back of your ticket anyway. What you're doing by saying that is you're telling the officer, I don't plan to fight this. I don't plan to go to court. I'm not hoping I'll ever see you again. I'm just going to get this over with and done with. So anyway, just don't make yourself memorable at all. Number two, once you get your citation, it's going to have a vehicle code section on there that you're charged with violating. And you want to know, obviously, what you're charged with doing. And it will say vehicle code 23152 or 21455.5 or whatever the number is in the traffic in the vehicle code. It's going to say that on your citation. And so when you get home and go online or go to the law library, if you want to, find out exactly what you did. You want to look at the violation in the vehicle code and read that code section. And you probably violated it, but you may not have been, and you might have violated part of it, but you have to violate the elements of the offense, and you can read it through step by step by step. Like it might say, a person who fails to stop where a stop sign is posted has violated this code, blah, 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 or something. I don't know what it will say. Or if it's a cell phone ticket, it might say that you made a phone call, not an emergency phone call, by the way. If you made an emergency phone call, that's perfectly acceptable. But you might have made a non-emergency phone call without a hands-free device. Something that's still legal in California. I don't live in California anymore, so I'm not even sure what their cell phone law is. But anyway, my third point is delay your case for as long as you possibly can. And this starts right off at the arraignment phase. Okay, when you get your citation, on the bottom it'll say, I promise to appear in court at or before this date, on or before this date, 8 a.m. or whatever time it says, and in whatever traffic court it says. And what you want to do is postpone every single aspect of your case as long as possible at every step. So what you would do in that case is, whatever date it is, you want to set a cell phone alarm or calendar alarm so that you will not forget and take off work or whatever you have to do to go down to the court. Or maybe you can call the court clerk and say, can I plead not guilty by mail or on the phone, or can I waive my arraignment? They might say, yes, you can, and then you have to send in your bail out probably at that time or something. I don't know exactly what will happen there, but they'll set a trial date at that point. And so what I would recommend is wait until probably 3 or 4 days before your appearance date that you promised to appear. And then call the court clerk or go online and see if you can postpone your arraignment. They might let you postpone it for 30 days or something like that. And if that's the case, you have an extension of 30 days, and then set yourself a new alarm so that you're sure you won't forget and you will be in court on before that date. And then at that point, when you no longer can extend your arraignment at all, then go into court and plead not guilty if you can't do arraignment by phone or somehow waive the arraignment or set trial date before you're pleading. Now, when you go to court and you're arraigned, at that point you still haven't posted any bail, most likely, and the judge will, when you get to court, if you plead not guilty and you want a trial on the matter, then you will have to post your bail at that point. They probably won't allow you to go on your own recognizance, and maybe they will, but you need to have cash or a check with you or something or a credit card that you can post your bail with. And so the officer won't be there. You won't see the officer when you go for arraignment, but you'll go in and you'll post your bail, and then they'll set a trial date. Then when the trial date happens, you want to try to extend that and postpone that as long as possible too. So you want to go online or call the court clerk at, when it's like 4 or 5 days before you're supposed to appear in court. Call and say, can I get an extension of time to appear in court? And they'll probably say, yes, you can, especially if you've already paid your bail amount, because the bail amount is your fine amount essentially as well. And if they already have that money, then they're fine. They don't have a problem with you postponing things generally. And I've postponed a case 8 months total. I have a friend who postponed his case over a year, and until he finally got his decision in the case. So, and the reason I say postpone as much as possible is that every officer at some point retires. Every officer at some point changes divisions or changes departments in where they work. They might work in traffic division for 2 years, and then they go into detective division, or they go into patrol or some other aspect of the police department. They might go to internal affairs, or they might become administrative or something else. And so this officer that gave you this citation in 2 years, 3 years from now, or whatever, may not even be doing traffic court or citations anymore. And if they go to a new department or retire or die or anything else happens to them like that, then they're not probably going to come to court when you finally do get into court to have your case heard. And if you've postponed your case for 6 months or a year by asking the court clerk at every turn possible, can I postpone my trial date? Can I postpone my date? I haven't got all my evidence in together, or I haven't, I'm still doing research, or I'm trying to find an attorney, or whatever things you want to say. Get your case postponed as many times as possible for the greatest length of time possible. And at some point, like I said, you're going to have to post bail anyway, and then they're going to have your money until you're acquitted, if you're eventually acquitted. So anyway, postpone. Let's see. And if you do win by that strategy, by the way, you'll probably never know why. They're not going to say the officer retired. Sometimes the officer will forget what happened, and they might just say, "Look, I'm not going to go to court. I have no idea." They've probably issued 600 citations between then and when you got your ticket. They're not going to worry about going to court at that point, because they'll just look stupid if they can't remember anything at all about what happened. So they might have thrown their case notes away. They might have thrown their traffic ticket book away. Usually they'll write notes on the back of their copy of the citation, and that could be in a traffic book that's already gone into the trash bin. And then they don't even have anything. They don't have a memory of what happened, and they don't have any more notes of what happened. And that's just because you delayed enough that went way past, the time frame that normally people do, because usually it's over in 30 to 45 days. And they don't keep books for 6 months or 7 months at a time. So anyway, so next, this is number 4 on my list: do trial by written declaration. In California especially, you want to always do trial by written declaration. And again, if you get David Brown's book, this is going to be in there. It's going to tell you why to do trial by written declaration. Basically, it's a form that you fill out. It's called the TR-205, I believe is a form number. You can get that online. And fill that form out, and it'll have your name, it'll have your citation number, it'll have the date of your offense, it'll have your the code section you violated or whatever. And then there's a place for you to write in there what happened or didn't happen. It's basically writing your side of the story. And if you do that, then you'll send that into the court. In this case, it'll be with your bail amount. And you will do that before your honor before. Well, I need to actually research that, but anyway, you need to do that by honor before your appearance date. So whatever your appearance date is, either the date on your ticket when you got it from the police officer, or it's the date that you have extended that to, whether you got a 30-day extension or you've had more extensions. Your appearance date at any given point, the court clerk will know what your appearance date is. And so you want to send it in with your bail amount. You don't have to send it registered mail. You can if you want. I would recommend a trackable method of delivery, unless you want to walk it in to the court. And if you walk it into the court, you want to take 2 copies of your trial by written declaration. Go to the court clerk and ask them if they'll stamp one of them with their stamp, and it'll have the date that you submitted the declaration. And again, you will have to bring your bail amount with you to the court when you submit the declaration. Now, if you're indigent or you can demonstrate that you have no money, there may be an exception for that. But generally, you have to turn in your bail amount when you turn in your trial by written declaration. And then they will notify, the court clerk will notify, and this is all in the California Rules of Court if you look up. If you look up trial by written declaration, the court clerk will then notify the police agency and the officer who wrote the citation. John Smith has contested the violation in writing. You have, I think 30 days to get back to us with your statement of what happened. And then the police officer will fill out a form, and it might be TR 206 or whatever. I don't know what the number is, but they'll fill out a form that'll say their badge number, their name, the date of the violation, all that stuff. And they'll say, yes, they did commit a violation, and this is why. I still remember blah, 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 blah. And then at the end of that those two documents, what you wrote and what the officer wrote, go into your court case file, and that's forwarded to the judge. Now, if the police officer doesn't respond within the 30 days that I think they have to respond, there's a defined time limit, then that file goes to the judge without their declaration, without the officer's declaration. And that's just as good as them not showing up in court. So the judge will open the file, and unless you admitted the violation in your statement, like, yes, judge, I was going faster than the speed limit, but I had to get to the football game, and it was a very big game, and I couldn't afford to be late for the football game. That's not going to get you out. In fact, that's going to convict you, most likely, even if the officer doesn't write a statement. It's quite likely to convict you, I think. So just don't admit guilt in your side of it. You can either say, I stand by my not guilty plea in this matter, and I'm respectfully requesting trial by written declaration. Or if you have facts that you want to state that support the idea that you're not guilty, like I was in Europe at the time, and here's my airplane ticket or something, then that would be something that you could do, that you could put in as supporting your innocence in the case. That would be that you're factually innocent of the violation. But if you're not factually innocent and you don't want to lie in the declaration, just be as evasive or vague as possible and just say you stand by your not guilty plea and you don't, you respectfully request trial by written declaration or something like that. And then that's it. You don't have to say any more. And if the police officer does not provide the testimonial evidence to convict you, and or maybe they have radar evidence that they want to produce, or maybe it's a red light camera ticket, and they'll send in their photographs to the court that the court can look at in determining whether you're guilty or not. And I've, in my experience, at least half of those don't get responded to. If it's not responded to, you'll get a note in the mail that'll say you've been acquitted in this case or found not guilty in this case, and they'll give you your money back in a check from the county clerk or somebody like that. And you may not even know why. You may have made an argument in a red light camera case or some other kind of case that the judge found persuasive, and when the officer submitted the evidence, your argument overruled or outruled or outclassed whatever the officer said in terms of evidence, or whatever the officer provided in terms of evidence. And if you said, for example, that you think that your county's program of red light cameras is illegal, or your city's program is illegal, based on the provisions of the vehicle code, the judge might throw out your case or find you not guilty on that basis, but you may never know why. You might just say you've been found not guilty in this case. You may never know whether the officer even responded. I read one of my notes online because in Ventura County they put, at the time, and I think they still do, they put your case history online. You can put your driver's license number in and your name and your date of birth and see all your charges and all the dispositions of all your cases. And I always like to do that because it showed me 4 cases that I beat in the courts, and I thought that was just, it gave me a warm fuzzy feeling to just go look at the page. But anyway, on one of them it said, for unknown reasons, the police department did not send photographic evidence into the court. So that was it. I mean, I don't know why they didn't, if they lost it, in the shuffle, or I think a lot of times these things get handed to an officer in a briefing and they say, here, you have 30 days to respond. The officer puts it in the locker or forgets about it and then just doesn't bother. They don't really get paid extra for that. Like they do if they go to court, they get paid overtime for that. But anyway, okay, let's go on to number 5 then. If you don't like trial by written declaration result, if you get convicted, then you're not going to like the result, I can tell you. So if you get convicted, you can request trial de novo, which means from new or from the beginning, basically, in the Latin. I don't speak Latin, but that's what I think it means. So you can request a new trial by in court after you're convicted of trial by written declaration. And here's another reason that the TDD is so important to you, because if the officer wrote a statement or provided evidence to the court in your conviction when you were convicted at TBD, then you can go to the court clerk and ask to see your case file. And your case file will have the TBD that you wrote, the TBD that the officer wrote, any evidence the officer provided. And that could be very beneficial to you, because if you take that into court, if you make copies of that and bring that to court with you when you do go to trial, if the officer testifies any way differently in terms of material facts, in any appreciably different way, you might be able to challenge the memory and the credibility of the officer's memory in the trial de novo. And it will be up to the judge, what you need to show. Like if the officer said for some reason he mentioned in his TBD that you were wearing a dark blue shirt, but then in court he testified that you were wearing a light blue shirt. I don't know that would necessarily, help you that much. But if there are material facts that are changed or that are different in what they say in court compared to what they wrote in the TBD, that would be something you'd want to be able to point out to the court and then challenge the officer's credibility, either based on loss of memory or based on the fact that he's lying, which is not most likely. Most likely they just forgot or they, made a mistake. But that would be a reason to challenge the officer's credibility. So anyway, after you get requesting trial de novo, then go back into the delay tactics. Try to set as long a trial date as you can. And then when it gets within 4 or 5 days of that trial date, try to get another trial date set. And keep on doing that as long as you can to keep extending the date. And thereby you're reducing. Every time you do that, you're reducing your conviction chances by 2% or 3% or something like that, just depending on when that officer is going to retire. If they have a 20-year career, even if they worked in traffic division the whole 20 years, any given year, there's a 5% chance they're going to retire, right? Because they could be, when they issued your citation, they could have been in their 19th year or they could have been in their 2nd year. And it's possible, it's a 5% possibility that they could retire in the time that you're delaying all this stuff. And the court clerk is probably not going to know. The court clerk is not going to know that this officer is retiring on June 1st. So if you're asking for extensions into July and the officer actually does retire on June 1st, you're never going to hear about that. They're just not going to show up, and you're going to be acquitted at that point. Anyway, next, when you finally get to court, if the officer shows up, disqualify the judge. And there's two real good reasons to disqualify the judge. First of all, if they are a pro tem judge, and you should be able to find that out by asking the bailiff, or they might even say on the door of the courtroom, you might have had to sign a form that says, I don't object to having my case heard by a pro tem judge, or whatever it is. Whatever the thing is, I would say, Your Honor, I respectfully ask to disqualify you based on the fact that you're a pro tem or temporary judge, and I'd like to have a full judge hear my case in the court. And that judge will very likely disqualify himself or herself on that basis. And then again, if you can delay that until the point where you determine whether the officer is there or not, obviously you don't want to disqualify the judge if the officer doesn't show up, because if the officer doesn't show up, then you're automatically found not guilty, most likely. Or at least you should be, unless the judge is corrupt, which is possible, but not very likely. So, and then if for some reason you can't disqualify the judge as a pro tem, then use PC 170.6. And Penal Code 170.6 says that you can disqualify any judge one time, or you can disqualify one judge in the course of your trial. This is similar. It's called a peremptory challenge. It's similar to the same challenge that lawyers use to disqualify jurors in a case. In a case, you might have been disqualified as a juror yourself. I have, for whatever reason. The plaintiff's lawyer, or whoever's lawyer, didn't like me, and they said, Your Honor, we want to excuse number 13 or something like that. And then you're done. So you're basically excusing the judge from the case. So it's Penal Code 170.6, I believe. Look that up. And like I said before, that applies in traffic court cases, just like it does in felony cases and other criminal cases. And again, look at David Brown's book on that. I think it's PC 1054.1 or something, and 19.6. Look those two penal code sections up. And when I say look them up, what I'm saying is read those sections. They're not that hard to read. They are written in English. Anybody who reads those codes can understand what they're saying. And it's just written in plain English. And it basically says that if you put those two code sections together, 1054.1 and 19.6. Excuse me while I turn this TV on. Then you can apply any provision of criminal law to your traffic court case, except for the jury trial. And I think there's one other thing you can't apply to your case. And use that and cite that section, and the judge will most likely disqualify himself or herself. Now, if you're late in the afternoon, and I would prefer an afternoon arraignment to a morning arraignment. If you're late enough in the afternoon when this happens and you disqualify the judge for whatever reason it is, your trial will probably have to be set on a different day. Okay. So in this case, if you disqualified the judge because they were a pro tem judge, let's say, either case, your first time in court or your second time in court, if they were a pro tem, disqualified for that reason, that's one. 170.6, that's two. Late in the afternoon, if there's no courts available or no trial judges left that can hear your case, that's three. There's three separate times that officer had to show up in your trial. Not just, you don't want to just leave it up to the odds on one shot. Try to make them show up 3 times or however many times. Any number of times you can make that officer show up, make them show up, and hopefully one of the times they won't show up, and they might not. And the more you extend it and the more times they have to show up, the better your chances are. Also, you do have a right to a decision in your case on the day when your trial happens. So when you get to court, if I don't know how that works actually in terms of disqualifying judges, whether you can enforce that. If you disqualify a judge and then also want to also enforce that same day trial rule and same day verdict rule, actually, they have to proceed with your whole case and get you a verdict that day before midnight. If you want it, you might be able to get a dismissal based on the fact that the judge was disqualified and there are no further judges available to hear your case. You'd want to probably research that, or just try to ask the judge and just make the motion. Your Honor, I request that these charges be dismissed because I have a right to a decision today in my case under California law. And if he or she says, that's right, you have a right to a decision today, and I can't give you one, and no one in this court can hear your case today, so you're done. I'm not sure if that works or not, but you might want to try it or look it up and see if it works. Maybe it will, maybe it won't. Anyway, when you're in court, this is my 6th tip in this list. always address the judge as your honor. I would say without fail. Every time you address the court, I would say, Your Honor, I object to what the officer is saying, or blah, 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 or what the officer is doing. He's trying to pretend like he's an attorney when he's really not an attorney. Whatever objection you're going to make in your trial, Your Honor is the proper way to address the judge. When you go up to the stand, if no one else has used the terms in the court, I wouldn't care. When I go up to a witness stand, I would say, Your Honor, thank you for hearing my case today. And if they're going to give the police officer a chance to speak first because they have the burden of proof, they're going to present their evidence or testimony. And then at the end of that time frame, the court will say, did you want to ask any questions of the officer? And you can cross-examine the officer depending on whether you think that's beneficial to your case or not. But either way, you say, Your Honor, yes, thank you, I would, or no, Your Honor, I prefer not to ask questions of the officer. But just use that as a way of addressing the court. It's a way of showing respect. And as well, you want to show respect to the officer. You don't want to say that you think they're stupid or that they call their hair funny or anything like that. You just want to be respectful of all the people in the courtroom, and don't interrupt people or argue with the judge. Obviously, I wouldn't do that. You can make a motion, or you can respectfully say, Your Honor, respectfully, I disagree with your interpretation of this or that. But you use the word Your Honor in any case when you're talking to the judge. All right. Well, anyway, those are some of my points generally for traffic cases in California. Regarding traffic cases in California. And again, I will recommend the book by David Brown. I will recommend highwayrobbery.net, especially if you ever read that camera ticket. And I will also recommend helpigotaticket.com. Just one word, help I got a ticket. And those are both very good websites you can look at. I have talked to both of those gentlemen on the phone that made those websites, and I've used information off of those websites in cases I've had. So they're very beneficial websites, very good websites. Anyway, I hope that you've enjoyed this. I don't know what I'm doing here. Oh yeah, it's an internet video. Hope you've enjoyed it, and I would be happy to answer questions if I can. Obviously, if you have a DUI or reckless driving or something, you probably want to seek the advice of somebody who actually knows what they're talking about. And good luck on your citation.